I can take you to the pre-amendment version of the Act itself. If we could look at the notice of motion together with the Act. So the notice of motion attacks section 8.2, 9.1a, etc. In paragraph 1. I'd like to focus on 8.2. We'll go through each section and I'll explain what our argument is. So 8.2 is the section that says a political party may not accept a donation from a person or entity in excess of the prescribed amount within a financial year. Is my Lord there? The ladies? That is to be read with the regulations to that Act at Regulation 7. Sorry, at Regulation 9. That's also attacked in paragraph 1 of the notice of motion. It says a political party may not accept a donation from a person or entity in excess of the prescribed amount. And then paragraph 9 of the regulation says disclosure limit. The threshold referred to in section 9.1a, the one that we've just read, is 100,000 rand within a financial year.
Mr. Masevich, we do not have the regulations in the bundle, so perhaps if you want
Sorry,
to add
I think it's at the back. They are attached to the Act. They should be attached to the. Are they not on your version?
I think it's best if you hand up a hard copy.
Yes.
Then we can look at the section together with the regulations. Otherwise, we're going to be turning.
Absolutely. No, we have those. We have those. That's. I'm really. Right.
Are you dealing with the pre-amendment?
Pre-amendment and post-amendment.
Because the regulations to the post
So this is
those are
the pre-amendment and that's the post-amendment. Right, so the one with highlights in the front, on the front page, is post-amendment. The one without the highlights in the front is pre-amendment. My Lord, my ladies. So what I was, now that you have the version that I'm working from, it will be easier. There's pagination at the bottom of that document. 6 of 14.
Of the
pre-amendment.
The pre-amendment is the one without highlights.
Correct, my Lord.
Where do you see page?
At the bottom right, it has.
Of 14.
I'm looking at 6 of 14.
So I take it this wasn't paginated in your bundle.
This is not from our bundle. Our bundle only contains the amended version of the. But there is a.
So you knew on Friday when you sent us
No, I realized this morning.
the volumes that you're not sending us everything.
My Lord, I realized only this morning.
That also we landed on the bench this morning. The blue file, the Linden's file. You knew on Friday when you sent us that bulk that you are not sending us everything that we need. Because this wasn't in there.
My Lord, I didn't know that this wasn't in there.
Why didn't you know?
Because it referred to the Act and it wasn't clear from the index that it's free or post.
what you were going to refer to this.
My Lord,
That's not the way we operate, Mr.
Yes. The Act, I think.
But carry on, we are wasting time because you wasted our time. Carry on.
Yes. My Lord, 8.2.
Yep, it reads the same in both here.
A political party may not accept a donation from a person or entity in excess of the prescribed amount. And if I could take the court to page 13 of 14. 9, paragraph 9 of the regulation. The threshold referred to in section 9(1)(a) of the Act is 100,000 rand within a financial year. Are you there? Is the court there? Yes. So this is those two provisions must be read together, and it's the Parliament that determined the 100,000 rand. We say that first of all, that 100,000 rand applies to every political party and every independent candidate without distinction. It applies in relation to related, so related entities can donate below the threshold. There is nothing in this Act and nothing in section 8.2 that controls for related entities. It's simply one limit per donor, whoever that may be, at whatever level, to a political party, a specific political party. So the other important point about this is that it focuses on the political party, on the donee, not the donor. So somebody could donate 99,000 rand to a number of, let's say, independent candidates or a number of parties, and no one would know that they've donated to those parties. All it says is that if a political party receives more than 100,000 rand, the respondents say in a year. We say that that's not clear from the legislation, because paragraph 8.2 says you may not accept a donation in excess of a prescribed amount within a financial. Sorry, is this 8.2 is the upper limit? Sorry, 8.2.9.1a. Sorry. No, sorry, I'm mistaken. It's 9.1a. Sorry, it's the one I intended to refer to is 9.1a, not 8.2. 9.1a says a political party must disclose to the Commission all donations received above the prescribed threshold, and that's the one to be read with paragraph 9 of the regulations. And that doesn't control for related parties, doesn't control for what level of government is involved, and the focus is also on the political party. It says that if a political party receives a donation above 100,000 rand, it must disclose. So if a number of political parties receive a donation from the same donor of 99,500 rand, that doesn't have to be disclosed. Also, if there are related donors who donate 99,000 rand, they don't have to disclose if they don't breach the threshold of 100,000. We say the way that 9.1a is framed, it's actually per donation, but the respondents argue it's in a financial year. I don't think it makes a huge difference one way or another. It still suffers from the same problems with related parties and the fact that the 100,000 rand is not tailored to specific political parties or the size of political parties. Yes.
Sorry, it's been dealt with by respondents. Their counter argument to this is that, well, this is an enforcement issue. You can look at then piercing the veil of the different corporate entities in order to ensure that there isn't a subversion of what's intended by the legislation. I'd like to hear a response to that, because that's certainly the argument they raise.
Yes.
Whether or not, how you overcome that argument.
Yes, and they say it's if they're simulated transactions, then that. The reality is, under this legislation, there's nothing stopping the incorporation of entities. It's just not proscribed. It's not a question of intention of the legislation. The intention of the legislation is to allow juristic entities and individuals to donate, and juristic entities can donate below the threshold without being disclosed. So there's nothing, it's not a question, it's just not proscribed under this legislation. And no one, even if you read, in whatever way you read this legislation, it doesn't proscribe Mr. X incorporating 5 entities and donating 99,000. he'll or she'll say that's what they intended. It's not; these are not simulated transactions. Simulated transactions where you didn't actually intend to do what you did. Here they did intend to incorporate an entity and donate from that entity.
But isn't there other legislative instruments that will deal with the attempt to bypass the intention of this act? Isn't there other instruments that will address corruption or undue influence other than this act? I don't think we can only look at the act in isolation. We need to look at everything. If it's a company that's making a donation, that's doing it for an improper purpose, then we look at the Corruption Act, Corrupt Activities Act, the Prevention of Corruption. We look at POCA, we look at the Criminal Procedure Act. We can't just look at this particular instrument in isolation and say because it doesn't provide for ABC, never mind that there's another instrument that does address ABC, this act is unconstitutional.
But there's nothing that addresses it. It's just not prohibited. If it's not prohibited, then you can't be found to
but
be
if the donation is made with the attempt or with the intention of corrupting or unduly influencing a political party, of getting a favor, that donation is made with the intention of corruption, then that aspect will be addressed by the Prevention of Corruption, will be addressed by the Corrupt Activities Act.
By PRECA.
And by the Criminal Procedure Act or the common law or other legislation that exists. So if the intention is a corrupt intention, this act itself may not have addressed it, but it doesn't mean to say there are instruments or legislation that does not address it, because it will then fall under the Corrupt Activities Act or POCA.
I just want to add on to that question because of that legislation. How far does Section 19 of the Act take?
Of this act.
19.3 in particular.
In the amended version. Oh. Yes. Yes. This case is so. The Constitutional Court, if it's a crime, if it's given for some illicit purpose, and it's a gratification in terms of PRECA or in terms of this section or whatever it may be, then it will be a criminal offence. That does not answer the question whether it is. There could be the Constitutional Court made a ruling in relation to disclosure of information, not necessarily where there's proven corrupt link, but where there's influence that person's donation could have on the party. It doesn't have to be an illicit influence necessarily. The voter is entitled to know about it. It's not a question of, we're not talking about, yes, if it's corrupt, well, of course it might be dealt with if the enforcement mechanisms are in place. That's not the point. And Glenister case dealt with this post hoc review issue in any event. It said post hoc review is not an answer to having the right structure in relation to the agency as a whole. So it's no good saying, well, there might be, if it's a corrupt transaction, we could potentially pick it up if the hawks are alert and alive to it, or someone makes a complaint. That's not the purpose of this legislation.
No,
The Constitutional Court.
Then I apologize, Mr. Mosevich, because my engagement with you was based on your submission that there's nothing in this Act that prohibits donations in excess of 99,000.
Yes.
There's nothing in this Act that makes any donation illegal. So my engagement with you was in respect of that aspect, that this Act need not render any activity unlawful if there is another Act that addresses the unlawfulness of the donation.
But Yes, Milady, I was simply
So
saying...
that was the context within which that engagement took place. Not that the act or that a donation needs to only be unlawful or with the purpose of a corrupt intention. So I understand your argument, but as I say again, my engagement with you was in respect of your submission that this act doesn't declare any donation unlawful.
Yes, PRECA existed, Milady, before My Vote Counts 2 was put in force, and the Constitutional Court wasn't interested, no, but the Constitutional Court ruled that there has to be disclosure of donations. They didn't, just because there's criminalization of bribery or corruption, and that could be, if it's a corrupt transaction, it could be picked up in that way.
We are missing each other, Mr. Mosevich. I am not engaging you on your whole argument. I was just engaging you on your submission that this act is irrational because it failed to criminalize certain donations. And my engagement was with you because if a donation was made with a corrupt intention, this act itself need not criminalize it because there are existing instruments that deal with it. It did not go to the full extent of your argument, only that limited submission that you made.
Yes, I didn't say that it didn't criminalize, I didn't say there wasn't other legislation that criminalized. You're quite correct that there is other legislation that criminalizes. I'm simply saying that is not our complaint. Our complaint is that the prescribed amount is irrational because it doesn't achieve access to information that the Constitutional Court said should be achieved. And it doesn't make sense, it's incoherent, the legislation is incoherent. It doesn't provide the parameters that it needs to provide.
Now, your client partook in the process of this lawmaking.
Yes.
We saw the minutes and the reports, etc. These issues were raised there as well, weren't
Yes, in the amendment.
they? For the amendments.
Absolutely.
Right, I see it's 1 o'clock, so till 1:45. That's it. Let's just find out. Anybody have particular difficulties this afternoon with time? Should we go over the time or not? Mr. Mosevich, as I have it, you've been on your feet for 1 hour, 2 hours 30, but we've taken about 15 minutes of your time.
Thank you.
So you still have 45 minutes
Thank you.
when you come back. So what we might want to do is so that we don't, who's up next?
My lord,
You,
my
Mr.
lady, so I'll be next.
Yeah. And for how long are you going to be on your feet? I'm just trying. You've got
given
1.5
an
hours.
Yes, 1.5 hours.
So we might want to come back at 1:45 and then we do your argument, which will take us to 3 roundabout there. Then he goes out to. I'm just thinking whether we shouldn't move it around a little bit so that we don't have counsel in the middle of the argument by this afternoon. But you can speak to your colleagues, because if we have the DA, Action SA, and the speaker, that takes us to 2 hours. But then we're already over after 4. So we might want to take Action SA and the speaker after Mr. Mosevich, if your colleagues are okay with it.
My Lord, as I have it according to your timetable, we end at 2:30 and then it's 1.5 hours until 4 o'clock. So if we end at 4 o'clock, then the executive ends at the end of the day.
We never know with the interactions from the bench. It might take a little bit longer. Then we have to breakfast the manager just before he reaches his. So the parties can discuss it so that it makes sense on how that we can have a complete set of arguments. If you feel you're going to cut it short,
I won't cut it short, my lord. I think I would need to.
yeah,
Just in terms of our prep, we worked on the 1.5 hours.
because both you and the DA, we could potentially slot in tomorrow morning then. And
If the court were
if the
minded to do
speaker
that,
and action SA, we can do them this afternoon.
If-
And then take a break.
yes, we could assist the court even better by giving the court a written note in response to the argument, which then the court
Afterwards.
doesn't have to take copious notes and the argument can be managed better.
You can advise us when we come back
As the court finds.
as to how you want to do it. I hate to have counsel interrupted overnight in their argument and then have to come back the next day. The registrars will liaise with the security to allow you in time.